Thank you all for joining us this afternoon for another CyLab seminar series, and in particular CyLab Business versus Law series. And I'm very happy to introduce our speaker today. He's the one I've known for quite a while, and we've had some interesting work together over the years. Ed Stroz of Stroz and Friedberg, and he's going to be speaking about the manipulation of digital evidence in investigations. I'll read you a little bit about Ed's background. He served for 16 distinguished years in the U.S. Federal Bureau of Investigation, during which he established the New York City FBI Computer Crime Squad, one of the first two in the countries, and I think that's when that's within what year?
96.
1996. And directed several significant FBI investigations, including the high-profile international case of Vladimir Levin, the Russian hacker who broke into Citibank. That was one of the first very big events that somebody couldn't just say in a very cavalier way, oh, it was a juvenile hacker, somebody on a skateboard from Mohawk. This was obviously a criminal enterprise. It was in the early 90s, and it was one of the first cases that highlighted a lot of the work that had yet to be done in terms of getting law enforcement ready for what was coming, getting corporate security ready for what was coming. So it was a very seminal case, and Ed drove that case. In 2000, he founded a private investigation firm and has assisted corporate clients in responding to internet extortions, denial of service, hacks and unauthorized access, and theft of trade secrets. He's also pioneered the concept of incorporating behavioral science into the methodology for addressing computer crime and abuse. An industry-respected expert on the threats of computer crime and abuse posed by insiders, and has authored a book on the subject and testified numerous times at trial as an expert witness. He has supervised hundreds of forensics assignments for federal prosecutors, defense attorneys, and civil litigants, and has conducted network security audits for major public and private entities. Earlier in his career, Ed successfully investigated several major financial crimes, including approximately 24 bank frauds, bank fraud, money laundering committed by corporations stemming from a $196 million oil trading scheme, kickback schemes in the stock market through an undercover brokerage firm, and a $1.1 billion fraud scheme at a bank in New York. So that's just a little bit about his background. I'm very happy to have him here today. Let's welcome Ed Stroz.
Well, good afternoon. It's an honor and a pleasure to be here. You know, I don't know how I have anything to say that would be news to people who are so smart in the area of computer science. It is an institution like Carnegie Mellon. I say that very sincerely. And it really is an honor and a pleasure. And Richard, thank you very much. We've known each other for a long time. This is the most technically sophisticated setup I've ever had to walk into. I have two electronic devices. I mean, God knows what happening to my innards and this thing. So I think the people can hear me all right. I get a little bit of feedback here. So-so? Louder? Should I? Cutting in and out? I don't know what to do about that. Keep going? All right. So at the risk of cutting in and out and the risk of being too loud for some people and maybe not loud enough, I will try to convey some things today on the topic of the manipulation of digital evidence in investigations. Now, you could teach a course on this. So in the context of a 45-minute presentation, what I'm going to try to do is convey to you a representative survey of the kinds of things that we run into when we are conducting investigations, usually in support of some type of litigation. Now, I can tell you that our firm, and it's not really my nature, I think Richard would agree, to brag. We don't have a marketing department that runs out and sells things, but I can tell you that we're kind of one of the firms of choice in this area. And many of the things that you read about in the newspaper, in terms of hacking incidents or email investigations, no, that's all right. You need to give me something else? Okay. This is the first manipulation of digital evidence we're going to talk about. Is this the one that goes here? It was a battery? Oh, okay.
It's usually if you have another microphone on you or if you have your cell phone on you.
You want me to throw this away? Or a BlackBerry, put it to the side in case they...
It all affects.
You got anything else you want?
Yeah, my gun won't... I am not carrying a gun in case people... Maybe that's better? A lot of heads nodding. Okay. Even an incident like that, you see what just happened. Now, something went wrong, or you have things just as we all do, and something had to be changed. Now, if somebody were to say that I gave a presentation one time, and that something happened, they couldn't remember which presentation was, but it required that we, there was something wrong with the audio, we had to make a switch. There's probably, I can think of probably 8 devices in this little scenario that would have received an impression and might have stored something to corroborate that little event that just happened. And that's really one of the lessons I want to try to get across today, is that very often computer science people and IT people, much smarter than I am about running systems, when we talk about security and evidence, very often they're thinking about the evidence of their system and the system that they built and how it works. That's definitely part of it. But I submit to you that most investigations and most legal matters are about human behavior. What did you do? Or what didn't you do? And once we define that question clearly, what kind of evidence might come into existence from what you did or didn't do? And do we find that evidence? Or does that evidence seem to be missing? And what does that imply? So I'm going to try to boil down. I've put together here a couple of examples to try to make some points. It's about 12 minutes after the hour now. I want to try to be respectful of your time, and so we're going to go for about 40 minutes, 45 minutes. And if somebody has a question during the presentation, you can ask it. I'm also going to allow some time at the end for some questions, and that might be a good time as well. So here it goes. I'm going to try to use the slides a bit. It's great that there's actually a monitor in the back. I usually don't get that. But there's so much technology here. And it works. Exactly. This little slide is just going to, if I had to boil down sort of what are the categories that we generally run into, and you'll see these categories evidenced in the examples. The first one is just data being removed from where it was stored. And you might think, oh, that, doesn't that sound kind of vague in general? It gets people in huge problems legally, and I'll tell you why. Second thing is data being inserted by somebody because they think it would be helpful, or they want to take this out and put that there. It's a huge problem. It is a form of manipulation in a legal context. Third one, data being converted into one format from another. Just think when you're sending email from one person to another, how many servers that email goes through, and in the transmission, what might happen to the coding of that document. Fourth, innocent manipulation. That could be an example of it. If I send you an email, and somehow the email systems that I'm using and what you're using are different, and the servers have different versions of Unicode on them, it might show up a little different in your mailbox than it did from the mailbox where I sent it. And I got to tell you, a lot of people don't understand how that can happen and see it as an example of manipulation. And in fact, the data is being manipulated, but it's really very innocent. Nobody's trying to do anything nefarious. Erroneous interpretation of data attributes. You can see me standing up here. I've got some gray hair, probably more gray than black at this point. But I can tell you, for the judges and the lawyers who we deal with, who are some of the most senior people in the field of jurisprudence, and who are smarter than I am, and are very wise. And when they were growing up learning the law and learning evidence, there wasn't a computer near them. And at this point in time, they are often asked to make decisions and interpret attributes of data that seem very straightforward, but a lot of times are subject to an erroneous interpretation as to what that means. It's a big category in my experience of making a mistake. Manipulation to mislead investigators. Sometimes that is buried within the computer code itself in some of the malware incidents. We'll talk about that. And the last part is malware residue. Sometimes some of the most insidious types of malware that we've run into, I don't know what your experience is here, will leave certain residue, or what do they call it now, data exhaust, in the unallocated space of a hard drive. A lot of times people aren't paying attention to the importance of that kind of data and either don't copy it or you just ignore it or write over it, and it's can have very big implications. So those are sort of the categories that we're going to be talking about. Let me start with an example that's pretty straightforward. I imagine everybody here remembers the Enron scandals and the fraud that went on. One part of the fraud had to do with Enron trying to book more revenue and more income than it was entitled to by selling a barge. That's right, it was actually a maritime vessel, and they sold it to Merrill Lynch. Now, some of you may remember this incident, some of you may not. And the way they sold it to Merrill Lynch was to say, well, we will sell this to you, Merrill Lynch, so that we will be able to book a gain. But Merrill Lynch really had no interest in buying the barge. So what Enron's executives said, well, you know what, we'll sell it to you, but then we'll buy it back within 90 days. Now, there's probably nobody here that studies accounting. I'm an accountant and a CPA. If I sell you something with an agreement to buy it back, it's not a sale. And if the accountants had known that the sale of that barge was accompanied by a repurchase agreement, they would not have allowed the sale to be booked as income. But do you think Merrill Lynch was going to do a deal like this without something written? Of course not. It's way too big of a deal, way too important. And a memo was written by one of the people in Enron that laid out the entire scheme, showed how it was going to work, that there would be a sale, what the vessel was, how it would be sold, what the transaction would be, when it would be booked, what part of the business would receive the income, how it would be purchased back. And it was a great memo. Some people printed it. And during the criminal investigation after Enron failed, people were given copies of this memo in paper form. And the question is, all right, that's the paper form. Where's the electronic version? It became known as the Immaculate Conception Memo because nobody who handled it said that they wrote it, saw it, read it, remembered viewing what kind of, where they saved it. And we couldn't find it in the Enron records. But we did go to Merrill Lynch and able to use a couple of techniques, including hash values and other things, to search within the servers of Merrill Lynch to see if we could find this memo. Now remember, we're already into a form of manipulation because somebody knows this is an electronic computer file, but they don't want anybody to find it. And we found it inside the home directory of one of the executives at Merrill Lynch who was a defendant in the criminal case. He was on trial. And the very fact that this document was inside his home directory, and I think it was actually a copy of a home directory, was devastatingly bad for him at trial. It showed a real sort of state of mind and intention. Now, that kind of knowledge and intent, you might think, well, is that really manipulation? You were manipulating things in the terms of the way the court sees it. This is a very easy, simple example. Because they believe that when someone says, here's all the memos and I don't have a copy of this, that you are telling the truth. And if it turns out, in fact, that you did have it, and it was within your directory on the network, it's really looking bad for you. Now, one of the interesting things about this is that when we introduced it for the government, we were working for the Enron task force at the time and introduced it. The defendant's lawyer started to make claims against us after we introduced the document and said, well, you found the document, but was the document ever opened? Or was it just saved there without being opened? All right, and we were able to answer that. And he said, all right, well, maybe he opened it, but how long was it open? Did he really read it? It's one thing to open a document, it's another thing to actually read it. And legally, these things matter. I mean, in fairness, if you open a document for a second and you close it, you really didn't read it. We were able to address all those points. And then, the one thing we didn't count on, the challenge that we got into, was the That night, towards the end of our guy testifying all these things and explaining these things, the last thing we didn't count on was somebody saying, well, wait a minute, the kind of computer that was used back then had a monitor that only displayed so much text. And we believed that when the memo was opened, if you'll notice, the incriminating, the really bad information about how this deal worked was on the second page, which scrolled down farther. I know, it's ridiculous. This is what you wind up against. So, even though it was on his screen, and even though he was viewing it, you can't prove that he read the text that actually established the criminal intent here, and therefore you cannot show he knew that, and therefore he can't be guilty of it. Proceedings came to an end that night, and our guy spent all night running down, in his hotel room, evidence to try to refute that. And actually, he was able to refute it, but the judge ended testimony, and we weren't able to get there. So my point in this is just to show you that even when, as a matter of computer science, you think you're talking about, a memo, and here it is, and, so there's no manipulation, it is unbelievable what the legal system will put you through in trying to establish whether or not you manipulated the picture and over-interpreted the evidence or got it wrong in some way. We still doing okay with the audio side? Okay. So what does this lead to? This is a good example of a field. I just want you to know this is my term. You probably won't find this in a lot of places, but it's really business forensics. When we talk about forensic science, we're talking about science in the service of the law. And you'd be surprised how many people get that mixed up. It's really using science to establish things in a court of law. You don't settle these things in a lab, you settle them in a courtroom. And there are some areas of forensic science like hairs and fibers, DNA analysis, things like that, that we really don't touch on too much at our firm. But business forensics, coming down with interpreting electronic documents and emails, is really a very big deal in our field because it is often what the courts are weighing and trying to consider in making a determination as to truth and justice. And I just give you a couple examples here. No, that's not me, is it? Okay. One point here, the third point there, a lot of times people think of what we do and how we help out, and they say, oh, you're the guys who come in and get people in trouble, right? I just gave you an example of this guy at Merrill Lynch who wound up going to jail over what I just told you. And that's true. But you know what? More often than not, we get people out of trouble. Because a lot of times, business forensics and digital evidence can show what didn't happen. And I can tell you this is a very new concept for many lawyers out there. If you are experienced at a level where you're in this class, you know, for example, that computers keep track of all the files that are deleted from the system. You may not be able to retrieve the deleted file, but the fact that the computer can show you what files were here and were deleted is very powerful for lawyers to be able to establish what didn't happen on a computer. And one of the things we do for our clients is very often give them a list of all the active files and deleted files and allow them to just use logic to interpret and interpolate whether or not a given file was on a computer. Because I'm telling you, many of the lawyers think of a computer hard drive like a desk drawer. And what I mean by that is if I open your desk drawer, I can show you what documents are in there. I can't tell you what documents were once there but taken out. The computer, on the other hand, keeps a record of the files that were there and then were deleted. And that is it really affects their reasoning, and it really affects what they ask the IT people to help them search for. Now, this is one of these silly little corporate slides, where's the data? I don't have to tell you how many places, data can come to reside. But it can matter more than you think. And even we get surprised. And it can be in ways that you wouldn't really expect to be very useful. So just to make the point, desktops, laptops, BlackBerries, even the last one there, retired computers. A few years ago, we were working for a law firm that represented a musical artist. You would know the name of this artist. These are very prominent, popular musicians. And they had made a lot of money selling a song. It's not the kind of song somebody with gray hair always wants to hear, but it was very popular. And they got contacted by another musician and their lawyers. And they came to our client and said, "You stole our song, and we can prove it because we have computer recordings with the same sort of beat track that we can show were dated earlier than the work your client or our client had actually done." So they were basically trying to say, you stole our music and we can prove it because we have an earlier recording. So the lawyers call us and say, "Can you help with this?" We said, "It depends. What kind of computers does the client use?" Well, in the music industry they use Macs a lot. And this is a few years ago. This is probably about 5 years back. And when we asked them all the logical questions about, okay, which computer did you use when you were recording this? What's the first computer that would have received this file? It turned out to be a Mac that was dead. The battery had gone bad. It was just lying around. Most people don't throw junk away like that, even though it's worthless. And so we said, well, that's kind of hard because date and timing, when we examine date and time, we have to examine the BIOS, so you kind of need the computer to be active and have live data in it. So we probably can't do that. But because it's a Mac, it had some interesting features to it. How could we establish the time? Well, I didn't know this at the time, but the more we looked into it with our forensics people, the Mac has a hierarchical file system. And what we were able to do was say, all right, even though we can't activate the date and time on this that well, and we've lost certain things, we can show sort of like the layering of data that went on this drive. And in this case, we found the file that was at issue. And we were having trouble establishing the date and time because we could no longer go back. And in law, you'd have to prove that the date and time was verified, not just on the file, but that the system applying that was verified. And we couldn't do that. But what we were able to do was find a file before the file in question was laid on this computer, and another file that was laid down afterwards. Neither of those files were in dispute in terms of their date and time. In fact, we could show through other means that everybody agreed that those files happened at a date and time that was on the face of it true. And therefore, we were able to interpolate the file that sat between them. And it comes down to basically inode numbers are not recycled, at least on that version of a Mac. And it became a way for us to date and time, put a date and time stamp on a file that was under challenge by somebody else. So we weren't able to really, who was manipulating things there? Basically the person trying to sue our client. But they took a chance that we wouldn't be able to prove it. And even when we found that the computer was dead, we thought we were kind of lost. But no, you're actually able to establish that. Here's an example of people getting in trouble or false allegations being made at court. I'm going to just try to condense this down to a quick example. Represented a guy one time who was working for one company on the West Coast. He took a job offer with another company on the East Coast. And when he left his employer, he made copies of certain files. When he left, but what he said was he only copied the files he was allowed to take. He didn't copy them all. The company on the West Coast hired a computer forensics company. They examined the data inside the computer that he accessed before he left, and they found that many of the files on the computer all had the same last access date and time at the exact same moment. And what they alleged was that the only way the last access date and time would change en masse like that all at once was through a copying action. And we looked at that and said, maybe, but maybe not. I mean, it's a logical inference. They were saying, how you can't read, hundreds and hundreds of files all at one time. What we found out when we were examining the computer, and it was a Windows-based computer, is that simply by opening up Word, the recents action will change the last access date and time for everything in Word. That's one way. A second way, if somebody just brings their cursor over a bunch of files on display and just scrolls down them right away and highlights them all, actually under Windows, or at least under certain Windows system, it changes the last access date, even though you didn't make an action to access it as we typically think of it. You remember I was saying people hear these terms access and it means different things to different people. And so we were able to go in and say, wait a minute, Your Honor, before somebody makes a determination that changing all these files last access date and time all at the same time is proof of copying and nothing else, we said, we're just going to run a little movie for you. And we showed an example on Camtasia to say, let me just show you. Here's the last access date and times of these 30 files. We did an example. We closed it. We then opened Word. We closed that, and we brought them up, and it showed that it had all been changed, and no copying action had taken place. We did the same thing with what's called a mouse over or cursor over and showed the same actions. It's very basic stuff. Huge legal issues can turn on actions such as that. So it's manipulation of evidence, even though you're not really thinking of it that way. This, don't worry, I know it looks like it'll put you to sleep, but this is what I often have to use this slide in order to explain to attorneys what kind of process is happening in litigation today and all the things that can go wrong and the way data can be manipulated. It's basically, in any kind of litigation today commercially, on the left-hand side, this is all the sources of data. You may not be able to see it that well, but emails and attachments, obviously, electronic documents apart from emails, database reports, internet browser histories, which are very important in litigation, files being copied from thumb drives, CDs, deleted files, fragments of data. The legal system considers all of that to be evidence. There is nothing that gets excluded unless the parties in the litigation agree to exclude it, and they usually don't do that. Well, all that data has to somehow be brought into a process that is going to boil it down into the documents and files that are relevant to litigation. And when you go through that process, see that big black funnel? If you're not really careful about this, you will change data. And a lot of times in ways that people didn't think was that significant. But the lawyers will often consider it to be enormously significant. So just to give you a simple example, the last access date and time can be the whole case in a file because it'll show what you knew and when you knew it. The last thing you want to do is make copies of that data and bring it into a process that changes it. So the metadata has to be preserved, and then at the very end on the output, we're trying to give the lawyers a distilled but undisturbed version of that data so that they can interpret it for litigation. I think that's all I really need to say on this, but it's an important, this, just what I just said here, is not understood by half the attorneys I deal with. So what is that boiling down to today? Well, as the lawyers get hip to this kind of stuff, and they realize that a file has a last access date, a create date, a date modified, a last written to, that there's a file system set of attributes that are very similar. The operating system has file attributes that are similar to that. In order to assert a position, you better make sure all that is consistent and not at odds with each other. We now have to design custom displays for attorneys to show them the electronic documents in a way that breaks out all of this kind of detail so that they can appreciate it. And don't worry, I'm not going to take you through all this. But this is a sample of a review screen for our review tool, custom made for attorneys, that allows them to examine the documents. You know that big funnel I was showing you? So at the far end, let me just go back to it. If we're over on this side, so that people can look at what we started with and what would boil down to be relevant, when they ultimately go to see it, it's now not only in native format, but in a way that shows all the metadata. So if you can see, like in these examples, who were the recipients, what are the dates, what was the date on the face of the document versus when was the file created. I've seen attorneys make mistakes just like, say I need something here today, and I ask somebody to fax a document over here. The fax file has a date and time stamp on it of today. I've seen attorneys make mistakes to think that that's the date that that document came into existence because that's the advice they got. Nobody was being careful enough to tell them, even though, yes, that date and time is a fact, it's not a you were misinterpreting the information. Now, that's a very crude example. There are more sophisticated ones, but I think you get the point. Also, what are some of the tools that are being developed to try to help attorneys appreciate these things? Well, It's not unusual for lawyers in a case, in a litigation, like in Enron and others, to look at a string of emails and try to understand the dating associated with it. Well, if it's a long string, sometimes these things only exist in paper form, too, by the time you catch up with litigation. You have to be able to identify a date, display it without changing it, and showing the attorneys where that date came from. You need a good audit trail so that they can understand and navigate back and forth. So we are developing, and the industry, we're not the only ones. I think we have one of the best tools out there because we're so connected to litigation that is really trying to show the lawyers the legal significance of the data in a file, not the sort of like data processing significance of it. We could do a course just on this. It takes hours to learn how to show the review tool, but at least I want you to be aware of its existence and why it is built the way it is. Now, here's something that you might find more interesting. Manipulation by malware. We have been brought into a number of the big instances of manipulation by malware that you read about in the press. I can't cite them by name because I'm not allowed to. And we're not in all of them, but we're in many of the big ones. So I think I can speak with some authority based on what I've seen in this area. First point is that the most serious forms of malware are the kind that secretly get in and transmit data. I was trying to make this point for years, and so was Richard to people. You know, people would come up to me and say, well, you know, what if my system gets infected? I said, your system probably already is infected. But what if it gets compromised? It probably already is compromised. And it was very hard for them to wrap their head around that fact. I said the most insidious forms of malware never want you to know that they're around, and they can be sitting inside your system. It's a business reality. Very often what we find is that the payload is going to hide within the system files. Again, it seems funny for me to be telling people like you these things because you probably know it much better than I do. But I can tell you from a legal significance, this has enormous legal significance. And even being able to find it. Very often the companies and the executives will just find it and clean it up. It shows they have no understanding how this stuff works. and to appreciate the difficulty and the subtlety of it is really a challenge. So the third bullet point there, this kind of malware is difficult to detect. This fourth point, it's difficult to account for what it did. Now this becomes very important legally because let's say, for example, a company is accusing a group of people. Say it happens on Wall Street. A number of investment bankers leave investment bank number 1 to go to investment bank number 2, and they're alleged to have taken data with them. Well, the investigation that goes into that is going to be greatly affected if it can be shown that that same network that you're claiming was victimized had malware on it that was secretly copying and sending this stuff off. Because now you're going to have to prove that even if you find it in the other investment bank, that they actually got it the way you're saying they got it as opposed to some other way. It's an innocent explanation for another way for data breaches to occur. One point I would just leave here is the last one, the remnants of the effects of this kind of malware. What we find is left in unallocated space. Now, I don't know how much of you, and I'm sure there's a lot of variation about examining unallocated space. We find that it is a very important part of being able to help clients, is to look in the unallocated space. And secondly, can you recognize and interpret the actions of payload of malware based on the way it deployed on the network and based on the residue that it leaves behind? You're all familiar with SQL injections and things of that nature. You're familiar with the web browsing and the kinds of things that can get on. What if the malware is designed, and we've seen this, to secretly copy data, zip it so that it doesn't get stuck in the firewall going out, clean itself up, nothing left in the active file structure anymore. But what you see in unallocated space is all the shells of the zip files that are discarded. Now, we've been in discussions with attorneys on litigation where literally the existence of a company hung in the balance with hundreds of millions of dollars in damages, all on the question of whether or not data can be shown to have left the network. Now, the first thing the lawyers come and look for are the logs. Well, this malware usually doesn't hit the log in a way that's going to be recognized. So they will say to you, well, you can't tell me that this went out of the system because it doesn't show. We don't see exfiltration evidence in the logs. Well, maybe yes, maybe no. It depends on your logs and how they're working. But even if we don't see it, what if you see the remnants of lots of zip files in unallocated space throughout your network when we can show that the payload of the malware on your network was designed to zip your data and send it out? Is there anybody here that would say that data didn't get exfiltrated? Or is going to say that the absence of an entry in the log file shows that it didn't go out? I don't think so. So it becomes very important. And from a manipulation standpoint, what can happen is sometimes the lawyers come into a situation and they agree not to examine unallocated space of hard drives, having no idea that that could be exactly where the answer to their evidence, the answer to their question may reside. So it becomes very important. And if you overwrite and delete that evidence, you've got another big legal problem, and a word that some of you may be familiar with, some of you may not be. Oh, this is just an example of an unallocated space hit. I sometimes try to use it for lawyers because they don't understand unallocated space, and we try to show them kind of the significance of what looks like gibberish. This is, it's about 42 minutes after. I'm going to hit this real quickly, and I do not mean to insult anybody's intelligence if you're familiar with the concepts of unallocated space and slack space and how sector by sector on a hard drive data gets stored. But this is, maybe what you can do is just understand, this is how I have to show it to the lawyers to understand. So here's a sector on a hard drive. File A is on there. File A is deleted. We all know that it doesn't get erased. File B overwrites File A when it needs that sector. But guess what? File A doesn't get fully overwritten. File B then gets deleted. Of course, it doesn't get wiped. And when the computer needs this sector, File C comes in. And it takes up maybe some of the space, because a sector can hold a fair amount of data. This concept is understood by probably 10% of the lawyers that I deal with. And I can tell you in many instances, we have gotten people out of trouble and gotten people into trouble, whichever way, it's whatever the evidence shows, based on things like unallocated, where you talk about slack space between what we find in A and what we find in B, even though it'll never be retrieved through the file system. So as we start to make these points to the attorneys and we show them examples, they sort of get the understanding, well, wait a minute, so we may not be doing the interests of justice if we don't come to terms with slack space in sectors. And they say, yeah, that's right. And they kind of get it, but when they see an example of it, like when we find a document sitting in slack space that was partially overwritten but is the smoking gun to the case. This happened to me one time where an executive, you would know the case if I was at liberty to say it, said he never opened up a certain spreadsheet that was crucial to showing what he knew and when he knew it. And we were able to find remnants of the Excel spreadsheet in the slack space. And you can't get it into the slack space in the form that we found it unless it had been opened. And that became pretty much dispositive for his side of the story. This is just a tool. We didn't build it. Payne Consulting makes it, showing Metadata Assistant. It shows a lot of metadata about computer files, deeper information about the last 10 authors, things of that nature. A lot of times people are not aware of these things, and we can show, and sometimes people will do strange things inside companies. They will cover up documents. They will try to delete documents. They'll manipulate them. They'll tell you they came about in a different way that they did. It's nice to be able to go back and look at the metadata through a custom-made tool for that to really understand what the metadata says about that file. And this is all internal metadata. These wiping programs, there's others. These are great names, aren't they? Evidence Eliminator, Active Kill Disk, Evidence Destroyer. One of these, I think it's this one, when you go to the website, they actually interviewed a guy in prison who said that he probably wouldn't be there today if he had been running Evidence Destroyer. It's a great testimonial. Except that might have been yesterday's game. Today's game in litigation, if you are found to have any of these programs on your computer, it's possible, in fact, I would say it might even be likely today, that the judge will issue an adverse inference in your case against you. This happened to, in the Coleman litigation, a huge litigation that got Kirkland and Ellis in trouble. And the judge said, yes, based on what I am seeing here and everything, you can't tell me that we have a pristine and complete set of unmanipulated evidence when evidence destroyer was being used, and brought onto the computer. And it's true. It's a state of mind thing. Because remember, in law, what we're trying to do is figure out what were people doing and what were they intending to do. Intent is a huge, huge part of law. And intent never is introduced in an envelope or in a box or with tweezers and it's put on the table. It comes in from the totality of the circumstances. So I'd say if you're using wiping software and you're anywhere near litigation, talk to a lawyer because you should either suspend it or get rid of it, but you want to go about it the right way. I think in the time I have, I'm just going to hit some of these things quickly so that we can get to some questions. These are just some points that lawyers find to be tremendously significant. And I could see a bright young group of people who understand the science real well thinking that lawyers understand this stuff better than they do. And believe me, the attorneys are super smart. They just don't know your field that well. But a lot of times we're talking about just deletion actions on a computer. We'll tell the attorney, hey, there's evidence of a lot of deletions of this guy's computer just before he quit. Well, nothing makes a point as well as when you just timeline it. And just through Excel showing, okay, and this isn't from an actual case. This is in 2005. An individual left company, deleted a bunch of data that he didn't want people to see, violated the terms of the policy of his employment, and was trying to say, I just delete stuff. Everybody deletes. I delete. We said, well, interesting. Here's how you've been working here all this time. Here's your deletion history. Here's when you got that offer and decided to go. Maybe it's innocent. But don't tell me you didn't change your pattern. Maybe there's a good, honest, and innocent explanation for this. But if you want to get in trouble in law, lie about something. It's worse than the problem itself. Yes, this is just a long way to say this is an example of how we saw evidence eliminator being used in a case. And a lot of times it's with flash drives. People come in and insert this stuff. And there is court case litigation now with legal opinions that are literally months old with devastating implications for anybody who does this. And one thing, if the lawyers don't understand the science, they certainly understand when a federal judge says, let everybody know. If I see this coming in my courtroom again, and somebody's saying this is all there is, turns out it isn't all there is, and you ran a program like this, you basically are over. This is another example, intentional manipulation. We have seen cases, somebody removed thousands of files from a computer, uninstalled and reinstalled an operating system, manipulated the clock. I can, in the course of this instance, be able to show you how we established these things. You probably have some idea. We were able to establish the file system metadata, the file metadata, the registry data, and the system logs, what had happened. And when you can show things like this happening on a computer, in a computer where the instance of that individual's life is under litigation, there's no way you can win that case. Because the other side will say, what I needed to prove my version of things was on your computer and you just got rid of it. I'm the one who's now been harmed. Thanks a lot. And the judges will agree. They're saying, no, in today's standards, you cannot do anything that would result in this. And if it shows intentional actions, as we show, it's pretty devastating. I'd love to show you some of the opinions. This is the word, spoliation. It's the destruction or significant alteration of discoverable evidence in the face of pending, imminent, or reasonably foreseeable litigation. So if any of you going into business or anywhere else if somebody tells you that you're in litigation, the company is in litigation, the department that you're in is litigation, they think it might be in litigation, contact the general counsel's office and ask them for advice. It'll automatically protect you because you get advice of counsel, And secondly, you won't make a mistake that could really harm you simply because you didn't realize how the law would treat that event. Now, so there's just sort of a bit of a rehash. Now, I know it's 50, I think we went for about 45 minutes. I hit a lot of things, and some of them kind of superficial, but I'm trying to, cover a lot of material for the course that we're trying to cover today. I would be happy to take any questions or comments, or did I say anything that sounds wrong to you or it doesn't make sense? So please. Yes, sir.
It is said that there are unique patterns to the way that people type, so that you might be able to discriminate one person from another or tell whether a particular person typed a certain sequence. Is that kind of thing of any use in your arena?
I couldn't have paid you to ask that question, because that is a fantastic question, and it touches on something that I love to lecture on. It's an entirely different thing. It has to do with what we call psycholinguistics. Not keystroke speed, but the actual way people communicate through the keyboard. The way they select words, the way they mistype words, the way they use phrases, the way they communicate under certain states, the words that they use. We actually have patented, not patent pending, but actually patented software that performs that. And what we do is we take psycholinguistic insights from clinical psychology that have been around for treating patients forever and have now applied them to examining email and language to see two things, kind of like what is the emotional state of the individual, and the second thing is to compare unknown correspondence to known correspondence to see if they are statistically significantly the same.
If I could just follow up on that, the process that you described is something that I would call authorship attribution, and I understand what you said. But the kind of thing I'm talking about is slightly different, perhaps. It is the rhythm with which somebody types a certain string, for example, that is your rhythm of typing, irrespective of what the word might be different from someone else's typing rhythm. And thereby you could discriminate among a set of people who may or may not have typed that particular string.
I think I'm getting, but when you say rhythm, are you talking about speed and impact, or are you talking about word selection?
I'm talking about speed and impact, not word selection.
Speed and impact, I know that that is a valid measure, but it is not one that we have any experience using. What we do have experience using is word selection. And not just to account for authorship, but to account for the state of mind of the author at the time. Because a lot of times, as I was saying before, that state of mind and intent becomes a very important part of some aspects of the law. And we try to show whether or not a person's state of mind was revealed in any way based on the words that they selected at that moment and how those word selections compared to their word usage over time. It's a little bit different. So I would be happy to discuss. I'd like to be able to pursue the area you're talking, and we have not done that yet. Yes, Miss.
Yeah, I mean,
I'll give you my card. Sorry, Miss.
it seems from your talk that whatever somebody does on their computer that is wrong, you will find out about it. If there are no evidence to kind of remove evidence, you will find out. Like you are great thing that whatever people do on your computer, you will find out about them. Are there ways people can escape you?
It may be a little bit of an overstatement, but what you're saying now, I find, remember the example I gave we had trouble with the audio system here, and all of a sudden, all these electronic devices are going to record actions that you wouldn't normally see, on, off, move, battery move, that sort of would indicate that kind of what happened here. So I would say that in the society that we're in now, there are so many digital devices recording things about where we are, what we do, and how we do it. It is hard almost to not in some way be betrayed by that. If you take an action or commit an action that doesn't touch on any computerized event or any evidence that way, I mean, I've investigated cases of arson, murder, kidnapping, and there wasn't a lot of computerized evidence with it. But when you talk about commercial litigation, which is where the evidence leads to very lucrative careers for people because the dollar stakes are so high, it's very hard to imagine a situation where there isn't a lot of electronic data. We investigated the case having to do with the Staten Island ferry and when it crashed a few years ago. Just look what's happening in terms of people texting on their devices when they're piloting digital locomotives. Even if the device itself doesn't have a computer, very often you find they were working with a computer that made some difference. It's a brave new world, and I haven't seen it all, but you really have to stop and look and say, what just happened that's under investigation, and what computers in that environment might have been touching that event, and would we examine it and look? And very often you find there's more computerized evidence than you would think. Yes, sir.
This computer has. Oh, sorry. Yeah. So my computer's got 2 or 3 secure deletion utilities on it by default. It comes with it. And I mean, I go out of my way a couple times to securely delete a sensitive file that has a password in it or something. But what's to say that my common practice isn't to do the secure delete option all the time, that there's very little left. Now, until I'm notified that I'm going to be subject to trial or something.
In that instance, if it is your routine practice and policy and your employer allows you to do it and you do it all the time, I don't see a problem. It just means that if litigation is anticipated, watch out. In one case, give you a quick example, investment banker at one of the top flight, it was actually an economist, top firm in the U.S., was actually, after he would get briefed from the Fed about what was going to happen, would call his friend or email his friend, and the friend was in New England, and he would then get rid of the email and, no more around it. But the person who received it was running an old version of Netscape with an appended text file back end, and he never deleted anything. And what we were able to do was account for every bit of correspondence from that person at the investment bank based on what the recipient's computer had on it. And it had to do with the kind of back end that he was running and his individual work habits. And once we established that, we were able to show exactly what this economist had done at this other place. It took the attorneys about 3 weeks to realize it, and they finally came around and said, you're absolutely right, and it's going to take his attorneys 3 weeks to realize that. And at the end, he pled guilty. But the point just being that if you are on both sides, what if somebody had something on this end and they're saying, and you sent it to me this way, and your evidence would show that you didn't, and then you're without it. So it's a double-edged sword. I'm not saying don't do it, but you really have to think, God, am I helping or hurting myself more with the presence and absence of this? And I don't think there's a simple answer to it. But I think that, so you understand, I think you're fine, but when litigation kicks in, you're in an exceptionally precarious position.
I wasn't talking about myself. Hypothetically.
Yes, sir.
Sorry, this mic. Oh, here we go. Okay. One thing I've always been very interested in from the legal standpoint, you were mentioning before how if you're using evidence deletion software, it could have an adverse effect on you in court. But what if I go into court, I'm under investigation for something, and I'm using full disk encryption? Like, how is that looked at if I just say don't want to give the password to something, or even if the RIA comes knocking on your door and they say you downloaded this, but because these network logs, but your disk is encrypted, could that just by default you into more of a guilty scenario, or is that less negative than evidence deleted?
Yeah, that's a very good question. My opinion on that is that there's no adverse inference from using whole disk encryption. I use it. Everybody in our firm uses it. All you're really doing there is putting a key on something. The danger is taking what's locked in that key and getting rid of it so nobody can get it. So when you are taking the protection to say, no, I'm not letting anybody read this unless they have the decryption key, and I'm going to give that up unless I decide to, you're within your rights. The only way where your rights would be challenged or they're forced is if a court order said no. If a judge issued a compelling action and said no, the interests of justice are more important than your privacy, and get to that point. But you would not be demonized for the action of having whole disk encryption. You would be in trouble for not giving up the password to get through it if you were under a court order to do so.
So
Because it doesn't. But whereas wiping software actually gets rid of stuff, you're not.
The worst that would happen with that is, what would you be, like contempt of court or something? I mean, I don't even know what, if you disagree to that.
Yeah, without pretending to practice law here, if you are the subject of a court order that is found to be valid, and you intentionally defy that, that is contempt of court. The implications for that, it's a criminal act, actually, contempt of court, and that they can put you in jail. I mean, that's what happened to reporters for a long time, right? I mean, they would have a source. FBI agents have gone to jail for not revealing their sources years ago. And they basically said, yeah, you can keep, you can honor, your knowledge of not telling anybody what your secret is, but that act in and of itself is contemptible to the interest of justice, and then you go to jail. But I would say, I would not demonize whole disk encryption anywhere as though I would with evidence eliminator and things of that nature. Good question. Yes, sir.
Do you ever worry about forged digital evidence from very skilled people?
Question. I don't have to repeat the questions here. This is so tech. I like this. I usually have to. Not only do we worry about it, we run into it. And in one instance, I can tell you of a case where it was enormous litigation with an Asian country, financial transactions, hundreds of millions of dollars at stake. And when the lawyers were looking at the evidence, there was one memo. This is the thing about law. Big things can turn on little facts. One word can make a big difference. One document can make a big difference. And one memo, the lawyers looked at it, and when they timelined it and put everything, said, I can't believe that this memo came into existence on the date that it is dated. There's no way that this guy could have known some of these things, and I just can't trust it. They came to us and said, we want to go back to this person in Asia to ask them about it. But it is so insulting to do so, and so dangerous for us to even challenge them, that we really have to know all we can before we talk to them. So the concern about manipulation, we said, all right, lawyers, you want to know more? You have to get the computer that purportedly was used to create the document. Because they just want to give you a copy of the file and say, well, it's not that simple. We spent days with the team of lawyers working on that and showed that it was manipulated severely, probably with state-sponsored help. Clock manipulation. You know what it is in Windows? There are so many things you change, you just can't get it all right. It's just too messy of an environment. And we said, we feel, and the lawyers agreed, because we explained it in legal concepts. They said, you're right, it is manipulated. They went back to that person, confronted him on the memo. And you know what he said? You're right, I did manipulate it. And yes, that kind of thing does happen. And I tell you, the lawyers, if they sponsor that evidence into court, get in huge trouble, including personal sanctions and the risk of losing their license. So they, in the U.S., so they take this stuff very seriously. And you know what? Anything that got their lawyers in trouble that much would really get the client in trouble. So the whole thing becomes very important. But yes, the manipulation does happen. We have had, I can think of 3 instances right now where lawyers have come in and said, we represent Mr. So-and-so. He just told me what happened. I believe him, but I just want to be careful. Could you look at his computer and basically address this question? And I can think of 3 instances where we've had to go back to the lawyer and say, your client is lying to you. Now, it's not what they want to hear, but they'd rather find that out in our office than find it out in court. And that's one thing, we do not become advocates for the client. We are advocates for the evidence. Whatever it shows, and a good lawyer will tell you, never fight facts. If your theory doesn't fit the facts, you get a bad theory. But if it's truly factual, and so I think what you see moving here, the interests of justice are appreciating what computer science can help establish in the way of fact, what did happen, what didn't happen, and therefore get to better justice. It's just not cheap because there's so much data out there and it's so subtle and brittle. In another instance, I saw somebody said, oh yes, I forwarded this email from myself to another person and I didn't touch it. And the lawyers looked at it and they went to the ellipsis points, and the ellipsis points in one version looked one way and the other version looked another way. And they're thinking, God, if she did manipulate this stuff, who knows what else she did? Can we trust her at her word? It looks like we went through and examined it. Turned out that the Unicode format changed the way the forwarded email was displayed on the recipient's computer. It's something I was alluding to, and therefore could innocently account for what had happened, and it wasn't manipulated. It was actually it's the system manipulating it. Because in some Unicode areas the ellipsis points are one character, in other points it's 3 periods, and that affects the way it displays.
One last question.
Whatever. I don't mind going a bit, so it's really up to you.
So regarding the previous question about encryption software,
yes.
So current software programs try to address the question of plausible deniability, which basically allows one to have a password that we can give, for example, to the court, where they would decrypt the data, but only see a subset of the data.
Mm-hmm.
So how would you say, from a legal viewpoint, how would that be seen from the court if somebody is using software encryption that would allow for plausible deniability? So basically, the court could not be sure if we are giving away all our decryption keys or not.
That's interesting. So you're talking about a subset of data as opposed to the entire corpus of data?
Basically, it's software that you can save data from starting from one side or from the other side. And if you give one of the passwords, it decrypts all this space without showing that there is encrypted data over the top.
As long as you can show that's what you're doing, and you are within your rights to use it, and the judge does not find any fault with it, you're fine. So so I think you're absolutely fine in that area. One case, we helped the government one time prosecute a bunch of animal rights people. Now, I love animals. My wife is on the board of the ASPCA. I love animals. But these were animal rights, not animal welfare. And they actually would go into people's offices and beat up people with baseball bats, blow up their cars, burn their houses. It was not a nice group. And they used encryption. And we were able to decrypt based on the way they were using the encryption and find versions of emails that were before they were encrypted that had been cached on allocated space. So a lot of times you find yourself in these situations and people then all of a sudden want to decrypt and introduce it into the court because they feel it'll support their position. And the bad thing about that is it really pisses off the judges. Because it basically, you are now trying to be judged. Like, all right, we're not going to show this unless I want to show it. So a lot of times your thought process in the law has to be first about technology, but then what does the law say about this? And thirdly, realize you're in a court of human beings who are going to be making inferences about your veracity, your truth, and your willingness to contribute honest facts. And remember, when you take an oath, it's not just the truth, it's the whole truth. If you're not giving the whole truth, they get concerned about that. So just internalize that little bit of lesson in deciding kind of how to use it. But I think you'd be fine if I understand the way you were introducing it. There was another question. I thought there was. Yeah, yes, sir.
I'll just be real quick. Have you run into cases? So there's a MD5 secure hash function that's been proven to be insecure. Have you run into cases where someone has intentionally created hash collisions to confuse your evidence or make reasonable doubt, whatever?
I know what you're referring to there. I have never seen, the circumstances under which they show the collisions based on having a similar file length and the same MD5 hash computation, that doesn't happen a lot. So I think even though it is not as dispositive as science would like it to be, I've found that people will accept that pretty well. And I have not seen an instance of somebody coming in and saying, all right, you have the MD5 hash value right, but let me show you the ways that can be wrong, and therefore, it should be thrown out and excluded. I've not seen that scientific proof used in any kind of weighty effect inside the courtroom, at least not yet. Well, this is yes, sir.
How often, in your experience, are the Doebert rules invoked?
The question have to do with the Doebert rules and being able to use science in the right way in a legal proceeding and be able to show that this will pass the Doebert test. Almost always it comes up somewhere. And when expert testimony is invoked, When we are brought into a case, the first thing we ask the lawyers are you asking us to be fact witnesses or expert witnesses? Because the only way our opinion can be brought in is through expert. And if you are an expert, then none of your work or work product is considered privileged. Everything is discoverable. So it really affects the way you go into things. Now, if you're going to be introduced as an expert, then Daubert becomes really important. If you're going to be a fact witness, still important, but a lot of times where it is invoked and the way it is considered is not with an actual hearing in front of the judge. It's more motion practice in documents between the two sides, the lawyers on both sides, and they just make a determination how they feel about the Daubert standard.